unique today that we have two witnesses before us, and because we've had lots of business without any witnesses, that's why I say it's unique. But we're glad to have them. And our first witness from 1 to 2 will be the Conflict of Interest and Ethics Commissioner, Mr. Mario Dion. And Mr. Dion, we'll let you go ahead with your remarks. Please keep them to 7 minutes. Thank you very much, sir. Mr. Dion, you're muted. You'll have to unmute yourself, sir.
So, merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. I would like to thank the committee for having invited me to appear today. It's been a year and a half since I last appeared, and in fact, we'll have an opportunity to exchange information and viewpoints this afternoon with the members of your committee. I understand that the motion deals with issues related to conflicts of interest connected with expenditures in the context of the pandemic spending. I have been Conflict of Interest and Ethics Commissioner since January 2018. I applied for the position because I believed in it and wanted to play a role in helping improve the confidence of Canadians in their elected officials and public sector leaders. I still believe in it, even more so now that I have a full appreciation of the role and its potential.
Members are new, so I'll take the occasion to give you a brief overview. We assist the House of Commons in managing the Conflict of Interest Code for members of the House of Commons, which was adopted in 2004. And we also do essentially the same work in relation to the Conflict of Interest Act, which dates back to 2007. The purpose of the Act is to set clear rules around conflicts of interest and post-employment for public office holders who may be either ministers, parliamentary secretaries, members of their staff, or governor and council appointees. There are currently about 2,400 public office holders, of which 1,300 are reporting public office holders, so they have additional, more stringent obligations. And of those 1,300, 700 are staff members in ministers' offices. The pandemic has had and will continue to have an impact on the work of our office because of course, of the two high-profile investigations related to the Canada Student Service Grant. As well, it has had an impact. We will discuss the issue involving Mr. McNaughton in a few minutes. So this, of course, has generated some work as well, and it was pandemic related. And in relation to that file, I ended up making an order against 9 senior officials involved in the matter, basically prohibiting them from talking to Mr. McNaughton for the next year. But the workload of our office has increased very significantly in the past year, but it's not mostly because of these things. It's because of a significant rise in the number of exempt staff. There's been an increase of 65% over the last year in relation to people who work in ministers' offices. And this is in addition, of course, to the 98 new members who were elected, new members compared to the legislature at the last general election. New ministerial staff and new members require, I think it's fair to say, they require more support. They have to quickly familiarize themselves with a complex set of rules and to provide a lot of information to us. So upon appointment under the Act, all public office holders are provided information on their obligations and a compliance process is undertaken. It's essentially the same thing as you've done under the code. Each MP has now completed the initial process. We analyze this information, and we also make sure that there is an annual review that takes place with each public office holder each year, each reporting public office holder. Throughout their term, public office holders must be vigilant about any recusals, any gifts of $200 or more, or any material change which they have to report to us in very short order. So, but our role is not only to advise, to confirm exceptions, or to explain requirements, but also to engage in oversight activities to ensure compliance with the provisions set out in the Act and the Code as well. Our role is to guide members and senior officials individually, independently, thoroughly, and consistently. And that's where the lion's share of the office's resources is directed. So although there was an important reduction in advice given by our office in the first part of this fiscal year because of the shock caused by the sudden onset of the pandemic on everyone's activities. That's my diagnosis, at least. It has since picked up. And I'm pleased to say that we anticipate year over year a marked increase. So people come to us, they seek advice, and that's the way it should be. Because while I'm not hesitant to use the enforcement powers provided for in the Act, I believe that compliance based on understanding one's obligations is always best. So, for example, in the middle of the pandemic last month, I should say, or this month, early this month, we organized an educational teleconference on the duty to recuse because I sense that there may be a need because it's very important to be able to identify situations where one should recuse himself or herself. So we had more registrants that we could accommodate on our Zoom license. We had over 200 people who registered for this 1-hour session on recusals. I intend to do more in the future on subjects, the high return areas where it really matters that you understand your obligations. So we've only had, insofar as the pandemic is concerned, I've mentioned 3 investigations which were related, 2 of which have yet to be completed. We also had only a few dozen requests for advice that do have a link back to the pandemic. So it's quite marginal. In terms of post-employment, because we will talk about the McNaughton file, there is a part in the Act. It's very short. It's 10 sections, and it sets out basically when you are a former public office holder, you have obligations, some of which are forever, some of which are limited for a period of 1 or 2 years after you've left. So I always invite people to read these provisions as they become public office holder because they should prepare mentally to abide by it with them once they will leave. But it's very seldom that former officers, officials seek advice from us. They are prohibited from doing a number of things. And so I'm not here to give you an exhaustive because I don't have the time, but I think it's important to situate the McNaughton matter to understand that Mr. McNaughton had been a reporting public office holder, had left a while ago, and basically engaged in some activities in which there were requirements in Part 3 of the Act, and which he did not follow. So he did violate certain aspects of his post-employment obligations and acknowledged that with the benefit of hindsight, certain communications and meetings, to the extent they could have furthered the interest of his new employer, Palantir Technologies, were contrary to Section 33. Si j'aborde la question des enquêtes,
dealing with the question of investigations, I have the power to do investigations under the Act or the Code. Generally, it arises out of a complaint from a member of Parliament, and I can also conduct investigations on my own initiative if I have reasons to believe that a public office holder or a former public office holder has contravened the Act. But I'm going to skip a few paragraphs because I think I've already used up all my time, Mr. Chair. But what I did in McNaughton is instead of a continuing investigation where there was an obvious problem with a certain number of breaches, I decided instead to issue an order to prevent those events from being repeated. So there were 9 public office holders who were prohibited from having official dealings with Mr. McNaughton. So I made sure that this situation will not recur, and this is in our public registry. Since I started my position nearly 3 years ago, we've had the objective of completing our investigations in a 1-year period, unless there are extreme complications. Since I was appointed, we have been able to fulfill this objective, and we've provided 18 reports, either under the Act or according to the Code. The interest is variable depending who is involved and the seriousness of the breaches.
I always hate to interrupt anyone, but we gave you an extra couple of minutes to go over, and I know my colleagues are going to hold me to account, so I will need to carry on to questions. And if you have something you want to cover, you can certainly cover it during our questions and answer period.
Of course. So I will stick to less than 2 minutes, as you will see, Mr. Chair.
I know you're already 2 minutes over. I mean, sir.
Okay, you mean we're over? Okay, that's fine, and I will cover other aspects. Okay. So yeah, that's part of questions and answers.
Time is always our enemy, sir.
Yeah, I know.
That's right. We'll move to questions.
I watch you on CPAC from time to time.
Okay. Mr. Barrett for 6 minutes.
All right, thank you, Chair, and thank you, Commissioner, for joining us today. Speaking of time, I'm wondering if you can tell the committee the expected timeline for your office to report your findings on the investigations of the Prime Minister into contraventions of Sections 6, Sub 1, Section 7, and Sections 21 of the Conflict of Interest Act.
No, I can't for two reasons. The Act prohibits me from exchanging any information while an investigation is in progress. But number two, even if I was not barred, I frankly don't know at this point how many more months we will need to complete the examinations that we've started in relation to Monsieur Trudeau and Mr. Morneau as well.
Okay, thank you. Thank you very much. Can you tell the committee what Section 9, or can you summarize Section 9 of the Conflict of Interest Act for us?
I will try, although it's always, sometimes it's more complex than it appears, but I'll try. I'll do my best. So Section 9. I still use paper because I was called in 1980, Mr. Barrett. So I open up the page and it says essentially that no public office holder shall use his or her position to seek to influence a decision of another person so as to further the public office holder's private interest or those of his relatives or friends, or to improperly further another person's private interest. So the focus is on seeking to influence the decision that has to be made by another person. So you occupy a position, you try to influence somebody else who has to make a decision in order to further the private interest of a relative, a friend, or to improperly further another person's private interest. So I know I'm reading back the provision to you, but I'm trying to put some emphasis on the key aspects of it.
Thank you very much. Section 9 of the Act is one in which you found that Prime Minister Justin Trudeau had contravened. Is that correct?
In the Trudeau 2 report, yes, we did. Yeah.
So being that it was a personal interest of the Prime Minister to attempt to interfere in the criminal prosecution of SNC-Lavalin, that's the very brief summary of your finding in that report. Would that be fair?
We found that he had improperly furthered the interest of SNC-Lavalin by seeking to influence the decision made by the Attorney General.
Now, not being a lawyer myself, on its face, it looks similar to Section 139 of the Criminal Code, which states that a person who willfully attempts in any manner to obstruct, pervert, or defeat the course of justice in a judicial proceeding is guilty of obstruction of justice. And those are not your words, sir. That's my reading the section from the Criminal Code. The reason I bring it up is I'm wondering if you can tell the committee if you were ever in contact, or if you're able to tell the committee if you were in contact with the RCMP regarding the Trudeau 2 report.
I am not able to tell the committee whether I was in contact with the RCMP.
Okay, thank you very much. We know that you had trouble, you stated as much in your report, the Trudeau 2 report, you had trouble collecting the information and that you were blocked at certain points during the investigation. Was that unique to that investigation, or have those hindrances or obstructions persisted in past and current investigations? Or more recent investigations, if you will.
No, it was unique to that investigation, and that's why I decided to talk fully about it in the report itself. I was surprised, and I wanted to take steps in the report to try to limit the potential for repeating the same situation.
And were you ever given any reasons? The clerk of the Privy Council did make reference to this during his well-publicized testimony at the Finance Committee this summer. Did you receive any insight into that obstruction or those difficulties on listening to, knowing that you're an avid CPAC watcher, on listening to Mr. Shugert's testimony?
No, I didn't. No.
Okay. So I think I'm just about out of time. So I'll ask, how might Mr. McNaughton's meetings and communications furthered the interest of Palantir? He said that in hindsight, he recognized that it could have. How might that communication furthered the interest of his employer?
If you've read the order, I'm sure, Mr. Barrett, and I should speak to the chair, of course. Those conversations, we had 17 conversations involving those 9 people who were directed not to speak to Mr. McNaughton anymore, and they were essentially to offer the services of Palantir pro bono. And pro bono is often the first step to a more lucrative type of situation. So it's on that basis that we decided to impose the order.
Thank you very much, Mr. Dion and Mr. Barrett. Now we'll move to Mr. Fergus.
Hey, merci beaucoup, Monsieur Dion. C'est un plaisir de vous revoir.
Thank you very much, Mr. Dion. It's always a pleasure to see you again. The first time we talked together, you were very generous and gave me great pieces of advice. Mr. Dion, my questions are more broad. Why do you think it is important that an officer of the Parliament such as yourself, who is independent and does the work you're doing, why do you think that is important? So yes, so that applies to MPs as well as public office holders. As you said, I think that objectivity and expertise are important. And you gain expertise after several years. So it's good to hire someone who is non-partisan and who has a lot of experience in a specific field. This will be even more important for the credibility of the whole process, which aims at regulating conflicts of interest. It's important to have an officer that has a 7-year mandate that cannot be fired easily. And it's important that this person is able to assess whether someone has violated any code or act. As you may know, Mr. Fergus, until 2017, my predecessors didn't have the same independence, right? Regardless of people's intentions, we are interested in the outcomes of any inquiry. But you are not that interested in the outcomes. As I said, MPs are the only ones who can legally file a complaint. MPs who come to us and tell us that something might have happened, yeah, it happens. And I know that MPs are also supported by their parties. So it's important to have people in my office who are objective and make sure that the inquiry and investigation will be as neutral as possible.
Come up with one conclusion and the committee were to arrive at a different conclusion on the same matter, would you consider that helpful to your work? Do you think that could...
I think the answer is, first of all, we have different fora and different set of rules. So you can, in fact, even if everybody does their work in a very competent manner, it is possible that the result might be different in one forum as opposed to another forum. I think it would not serve the credibility vis-a-vis the public that I was talking about. that on the one hand, the independent decision maker made a decision, and a committee, which is by definition partisan and displays partisanship, has come to a different decision. I don't think it would be a positive result for anyone involved.
Well, now
let alone the impact on the person who would be investigated twice as well.
Et voilà. But this brings me then to, and thank you for that. This brings me sort of to an interesting understanding, because I'm wondering if, in your opinion, who would be best suited then to conduct these types of investigations? Would it to discuss the ethical behavior of parliamentarians? Should it be other parliamentarians, or should it be you in your role as the Commissioner for Ethics and Conflict of Interest?
I think Parliament has spoken back in 2004, and until Parliament changes it, it's the code, and the code essentially has decided that the Commissioner would be doing this.
And that would be the best suited person for that job.
That's what Parliament thought in 2004, and I hope that continues to be the case.
Bon. Monsieur le Président.
Mr. Chair?
I have left.
Less than a minute.
Less than a minute. Let's see if I can just get in a quick question. Are we impeding your work by going to the same people who you are speaking to in order to try to come up with a fair assessment as to whether or not they contravene the code that was set in place in 2004?
I don't think it's not impeding our work. In fact, we follow with interest what is said at each committee. And I am currently seeking permission from the Finance Committee to be able to use the testimonials made before the committee without having to interrogate again.
Thank you very much,
Mr.
Fergus, Mr. Dion. And now we'll move on to Madame Goudreau for 6 minutes.
6 minutes. Thank you, Mr. Chair. Good afternoon, Mr. Dion. It is great to hear you speak French. I would like to go back to what we've been through, because I have some questions to better understand the situation. In a press conference, we remember that the Prime Minister recused himself and apologized for not recusing himself when the Privy Council decided to award the contract regarding the Canada Student Grant. So here's my question. How are you going to take those allegations in consideration in your review? Is it for you like a way to admit that something wrong was done? We'll have to assess if it's like a way to acknowledge that something was done or not done. So, of course, we're going to take that into consideration in our report. All right. Now, when we're talking about investigations under Section 44.3, in Section 21, it is said that public office holders should recuse themselves when they think they should. According to our expertise, are there any exceptions? Everybody should comply with Section 21. It is mandatory and applicable to any decisions. The public office holder should recuse himself when it comes to a discussion, debate, vote, or issue that could put him in a situation of conflict of interest. So that applies to all decisions, debates, discussions. All right, thank you. I have another question. With regard to the criteria of reasonable knowledge, Section 6.1. A public office holder should reasonably know when he is participating in a decision-making process and he is in a conflict of interest. For instance, a public office holder thinks that he might be in a situation of conflict of interest. How does the reasonable knowledge work? I see the section in a different way. It is forbidden for public office holders to make decisions when he knows or reasonably knows. So that's when you have to take a position. I have to analyze facts and make conclusions.
Là, voir si c'était raisonnable de penser.
We have to see if it's reasonable that the person ought to have known, according to the facts. There are a number of factors that will be taken into account, but there are moments when it would not be reasonable to suppose that someone knows everything about the members of their family or their friends. Okay, thank you. How much time do I have left, Mr. Chair? I would like to ask another question. 2 minutes, ma'am. Great. So I was listening to you, and I heard you at the meeting last Tuesday, and when we talked about your role as commissioner, conflict of interest commissioner, and also ethics commissioner, and I believe that I understood from your comments that ethics is entrenched in your title, but what about your duties as a commissioner? What about the ethics? My role in the area of ethics is fairly limited. There are 1 or 2 sections in the Act that use the word ethics, and one of the duties I have, which is not very well known to the public, is Section 43 of the Act, where the Act allows me, and in fact states that in addition to enforcing the Act, the Commissioner gives notices to the Prime Minister at his request, but not necessarily at his request, on applications under this Act or other issues related to this Act. So I am entitled to take the initiative and give unsolicited advice, and I think that this does create a certain role in the area of ethics, but that's about everything. With all due respect, Mr. Commissioner, I was wondering, I asked this question in view of the pandemic and considering a lot of the comments you made in your testimony. What about the relationship that you established to advise or to warn, because you're there to warn the Prime Minister who can make an application, and you can also have a watchdog function? Well, we have an ongoing dialogue with the public office holders. The higher their level is, the more often the consultations occur. So I understand then that what apparently happened ought not to have happened.
Monsieur Dion, Madame Goudreau. Prochaine députée, Monsieur Angus, pour 6 minutes.
The next member, Mr. Angus, for 6 minutes, please.
Chair, and thank you, Mr. Dion, for coming back to our committee, and it's good to see you in such good health, so I'm very pleased. I wanted to ask you, because when our parliamentary committees, Finance and Ethics, began looking at the questions around the granting of what was the $912 million grant, the Prime Minister testified that when this was brought to him, he became aware that there were potential conflicts because he was so closely tied to them, and that he asked for a period for them to do due diligence. In that time, did anyone from the Prime Minister's office or Bill Morneau's office reach out to you to regard whether there was a question of conflict of interest or the duty to recuse?
The advice we give to people such as Monsieur Morneau, Monsieur Trudeau, or any one of the 2,400 people I was talking about is confidential. The fact that
Yes.
they approach us, they don't approach us, I am simply not at liberty to discuss that. Under the
I
Act.
totally understand. I totally understand. It's just, it is very germane to the parliamentary investigation, whether or not that due diligence was done. So we will continue to look. I think what's been very complex for parliamentarians to deal with the WE issue is we are dealing with a group that is very, very complex in its corporate structure, multiple companies. Trying to get a clear sense out of some things is difficult. So when we were first told about the role of Margaret Trudeau and Sacha Trudeau, we were told they weren't paid. The board of directors were told they weren't getting paid. That was false. Committee testimony found out that upwards of $350,000 was being paid, but the Kielburgers said that they weren't paid to do public speaking. They were paid to do the ancillary corporate events, and so that's the big work afterwards in terms of the corporate sponsorships, which would be very lucrative to their organization. I know you can't reveal much, but would the issue of the ancillary events and being paid to work corporate events for an organization be something that you would consider part of your investigation?
We will look at anything that's related, even though somewhat remote. I'm not saying this is somewhat remote, but we take a very, very wide approach, and we will be looking at that issue for sure.
Well, I thank you so much for that. And Madame Gregoire Trudeau, who's been a strong advocate for youth, she, I understand, was given the dispensation to be a goodwill ambassador with WE, to run their blog. Are you aware if she was given permission to work corporate events on behalf of the WE group as the Prime Minister's wife?
I am not aware, and if I was aware as a result of our work to date, I would not be able to tell you anyway. So.
I totally understand. Thank you. I was very interested in reading your investigation into Mr. McNaughton, and I thank you so much for your positive response when I asked for an investigation, because I found it very troubling, because Mr. McNaughton has a long history in lobbying in Ottawa, so he's very familiar with the rules. He had said that he had cleared this with you, and in your paragraph 4 of your report, you said that you had following consultations. Mr. McNaughton, following consultations with the Office of the Conflict of Interest and Ethics Commissioner, was named President of Palantir Technologies Canada, effective September 4th, 2019. So did he discuss with you the parameters of his role? Because if he'd spoken with you, would it not have been clear he was not to do lobbying?
Every time I meet someone who wishes to discuss an offer of employment under the Act, when they're still a public office holder and they're planning their future, I invariably go through Part 3 completely. So I'm sure I did the same thing with Mr. McNaughton. Every section, including Section 37, which was key in this case.
Well, I would never second guess you. I am sure that you were very thorough, so I just wanted to clarify that. When I read your order, I find it very interesting because the order is against public figures from speaking with Mr. McNaughton, which I found interesting. But in the subject matter, Rick Tice, who's one of the Prime Minister's key advisors, it was discussion about Centre for Disease Control, talking with other senior officials, and it was all supposedly about COVID. But Palantir lists itself as a defense contractor. Were they discussions with the Chief of Defense Staff? What would that have to do with the COVID? Were they talking, are you aware that they were talking COVID or other contracts?
I'm not aware. When I say it's COVID related, I mean essentially the period, but and the team, I'm sure would and the order itself should reflect it, but I cannot answer the question today. I simply don't remember. So.
Okay, no, that's fair. It's because one thing I noticed, I mean, he seemed in a very short time, the doors were open. He met with all the senior officials, but he never met with anyone from the health minister's office, which I was surprised if he was offering to do work pro bono for COVID, that he didn't bother to meet with the health minister, but he was meeting with chiefs of defense staff and even up to the deputy prime minister. My sense of concern with Mr. McNaughton is that this seems to be a disturbing pattern that we do not want to go back to, where someone who's very powerful, who is connected to the prime minister, who worked as a lobbyist, who becomes a public office holder, and then walks right back in and is invited right into the deputy prime minister's office. How do we ensure that people comply with the law and do not abuse their political connections and the knowledge that they developed while serving as ambassadors.
Mr. Dion, you have to save that answer for another member. That time is up. Again, thank you, Mr. Angus.
Thank you.
Prochain Deputy, Mr. Gould.
And now the next member, Mr. Gould, for 5 minutes, sir. Thank you, Mr. Chair. Thank you to the Commissioner, Mr. Dion, for being here for our committee. We've had a big debate in our committee in recent weeks, and there is a question that came up that we could not necessarily talk about certain topics because you, as Commissioner of Ethics, were conducting an investigation. However, I would like to know whether you take into account the testimony in a committee that is on something that is underway or that is of interest to you, or do you monitor the work of our committee here? And if there are things that are of interest to you, can you take them into consideration? We attentively monitor the work of the committee. For example, this afternoon, it's a central mandate. It's my committee, in a sense, as far as the Act is concerned. This is a committee before which I appear, so we monitor the deliberations of this committee and other committees, not as much, but the PROC committee that manages the Conflict of Interest Code, and we take due note, and we cannot directly use the testimony when they're covered by parliamentary privilege, but as I mentioned, we ask permission for it of the chair to be able to use it, and we referred to the Finance Committee to ask for that permission, which we did 3 days ago. And should it turn out that anything was said before the committee of access to information and privacy and ethics, we're going to take the same process with your committee. But we cannot directly use what a witness says in order to report it in our reports. And one of the fundamental differences is that when I talk to a witness, invariably the person is under oath, which is not the case in one of these committees. Thank you, Mr. Dion. That will clarify a huge discussion we've been having here within our own committee. And also, Mr. Dion, a former member of parliament who left in December 2019, who had access and obtained a contract in the pandemic crisis, a contract of some $200 million. Can that be considered as privileged information or as a conflict of interest? Well, what distinguishes the code from the Act is that when one ceases being a member of parliament, the code no longer applies. So in the case of Mr. Bayliss, whom you didn't name, but I will name, we looked at that. Mr. Bayliss is no longer covered by the code and was not at the time when the discussions occurred and the contract was awarded. And as far as the code, it doesn't apply to Mr. Bayliss, quite simply. And we also took a look at what appeared in the public forum regarding public office holders involved in the contract, and we decided that there was no reasonable grounds to suppose at this stage that the Act might have been breached. Last summer, the clerk of the Privy Council and various situations in dealing with the We Charity, I had asked the question of where it came from, or the idea that We Charity had appeared on the radar, and we were told that it was at the request of the Prime Minister's office, and that even We Charity, because the day when the Prime Minister publicly announced that the program for students of We Charity, the Canada Student Service Grant, we had asked how We Charity had obtained the information, and the clerk of the Privy Council told us that he was aware of it because he had participated in developing the program with the responsible officials of the Privy Council, then the Prime Minister's office, and the eligibility criteria and the people in the program. So in view of the fact that an architect draws up the plans for a bridge, is it normal that the architect also signs the contract to build the bridge? Well, we will have to take a look at it. As you know, I cannot pronounce myself on hypothetical situations, and one has to possess the actual facts. So when we look at these aspects, the genesis of the awarding of the contract, and you'll read a report with interest next year, I'm sure of that. Thank you very much, Mr. Dion. So perhaps I'll turn over the rest of my time to my colleague, Chris Valentine.
30 seconds to your next colleague. Now on to Mr. Dong for 5 minutes.
Thank you, Chair. Thank you, Commissioner Dion, for being here today. It's actually my first time speaking to you, actually, in person or virtually. So first thing first, could you clarify for members of this committee and folks who are watching this right now, that was there or is there any indication that anything has been done by anyone in the public service, either the executive branch or elsewhere, or by members of this parliament that has prevented you from fully performing your work in this case?
So there is no indication whatsoever of anything like that at this juncture.
And thank you. Mr. Dion, do you feel or do you see that you have the full power to investigate issues on your own?
Yes, I do. And until such time as I face a big obstacle, I'm perfectly happy with the powers I have now.
So you don't need a letter from opposition to tell you which section to investigate or any suggestion like that, correct?
No, in fact, no, and it would be contrary to the law for me to even read your letter.
Mr. Dion,
as a committee of it.
I must say, as a new member, I'm quite fortunate that thus far I have not required the service of yourself and your office, other than the annual disclosure. But I do know some of my colleagues that it is a regular a practice, a good habit perhaps, to call your office for advice, and mostly just on matters of just as a matter of practice. And I just want to ask you that how are your advice being provided to members? Is it by writing, phone calls, or emails, or website? How do you provide those advice? I can't hear.
Okay. The preferred mode of communication, we never actually calculated it, but I have a very clear impression that it's email, followed by telephone, followed by very distantly by letters. People don't like to write letters anymore. So it's mostly email, which is good because it's good to have a written trace of advice we give you. And it's good for us to have a trace of what you told us when you sought the advice. So we can both remember the same thing a year from now when something happens.
And say, for example, that if a member of the opposition party or the general public thinks, for example, your advice is to set up a screen, and the general public feels that doesn't live up to public scrutiny, in that, would you feel compelled to defend your recommendation, especially when that can mean a big reputational consequences for the person involved? And if you feel that you do, and why, or why not?
Our role is to provide advice to MPs and to public office holders, and we do not discuss in any way, shape, or form the advice we've given them with the media or with members of the public. And the only body where I have to defend my advice and my decisions is Parliament itself and maybe the Federal Court of Appeal if somebody seeks judicial review. That's it. We don't have to justify, and we basically are barred from revealing any information without which it's impossible to understand the advice anyways.
Thank you. And I just want to go back to the conversation you had with my colleague, MP Fergus. I was listening carefully about the roles of the committee and your role. So, in your opinion, that should the committee not do these type of studies?
These types of studies being today's study, you mean today's motion,
yep.
or okay,
yep.
No,
or running a parallel investigation as you're doing?
I think today's motion is very different. It's not doesn't amount to an investigation. Of course, I would not welcome, but the committee is free to do whatever the committee wants to do. But I would not be happy that the committee is investigating something which is identical to what I am investigating. But the committee is free to do so.
Thank you. The reason why I'm asking this question is that what may happen is that if the committee and your investigation on the same matter yields different result, different outcome, or different decision, or different recommendation, in that case, do you feel that there's any requirement for you to defend your decision or your rationale publicly?
Sorry, I have to interrupt. The time has expired. I'll need to go to Madame Goodrow now for 2.5 minutes. Deux points. I'm going to have to learn that one. 2.5 minutes.
Oui, j'ai 3 questions.
I have 3 questions, Mr. Dion. First of all, you were saying that I wasn't sure if I understood you correctly. You were saying that a witness is not always witnessing under oath in front of a committee, but when the witnesses in front of you, it is under oath. Did I understand that distinction? Answer, yes, that's what I said. Question. Now let's talk about the report. The report is a substantial report. It implies a lot of work, and we will only get the results next year. And we're taking into account the fact that there's a pandemic. Everything's going very quickly, and it is very important for the public to have more trust in the process. And don't you think it would be possible to receive this report earlier? Answer. When I was talking about next year, I was talking legal terms. It doesn't necessarily mean that it will be in 12 months. It will be in the next year. So we could expect to have a nice surprise in the beginning of the new year? Answer. I'm trying to be very fair here. I want to do a good job and respect the law, but the sooner the better, of course. And here's my last question. I would like to understand the Act and understand paragraph 44. We're talking about Article 11, and that a designated public officer cannot accept a gift or another advantage, and there's a list. And I would like you to explain this article more. When you're talking about an advantage, what is this advantage? When we say the word advantage, or maybe benefit, I thought it was defined in the it's a gift. Basically, it would be an amount of money. If someone lends you money and you don't have to reimburse them, or it could be a service or a good that would be given for an amount that's less of the current value. Let's say someone gives you a condominium for $10. That would be a difference. Does this answer your question? Thank you very much, Mr. Dion.
5 minutes.
So would you like me, Mr. Angus, to finish my answer, or on what we can do to prevent former public office holders?
Mr. Angus, it's up to you for 2.5 minutes, sir.
Well, I will take my 2.5 minutes. And I think it's very interesting. My Liberal colleagues are very much trying to get Mr. Dion to tell us that we should not do our investigations because, of course, it's their MPs who are under investigation. It's an old standard. But I would refer you to the testimony. I don't know. You said you're interested in the testimony. July 22nd, Mr. Bill Morneau. 2 fascinating points. One, I asked him if he'd ever read the Conflict of Interest Act, and he seemed very, very surprised. And he said, well, he had been given a bunch of documents when he was first elected. So I'm surprised that there was no follow-up with him on conflict of interest. But that was where he told the public, and you became aware of it for the first time, that he had received $40,000 in travel. Now you have cleared, Mr. Morneau, and I understand that. Well, actually, I don't understand it, but that's your decision. I accept your decision because it's not so much that it's a gift, but it's a creation of a relationship with the Kielburgers. So on April 10th, 2020, and I wrote to you on November 17th about this, Craig Kielburger wrote directly to Bill Morneau, asked about his family, wrote in a very familial tone, and 11 days later had a $12 million contract. I find that to be extraordinary. Would you not suggest, agree that these kind of relations where people are being flown around and fed it and gifted, Mr. Morneau may have forgot that it was $40,000, but it created a relationship that could have influenced his decision, and I think under Section 7, with the obligation to not to show preferential treatment, that's an extraordinary amount of money to have been granted in a very short space of time.
If so, in 2021, there will also be a report dealing with called the Morneau 2 report, in which we will discuss all the various aspects of what went on between We Charity and Mr. Morneau. So that will be covered in the report itself, including the reason which led me to discontinue that portion of the investigation, and the reason why will be in the report as well.
Well, I thank you for that. Yes, I guess my concern here is that we're dealing with a very different type of political group here, where all the key ministers involved in the decision were feted and brought out to We events. There was a very close sets of relationships that made them able to call in, call favors in, and it was never seen as lobbying. And I haven't seen a situation like this before in terms of gifting events where someone's invited to big rallies. They get to be public speakers. They meet all kinds of famous people.
I apologize. You were way over there, so I need to move on.
Thank you.
Now on to Mr. Workington, and we're in the second round. It's 5 minutes, Mr. Workington.
I know we're going to run out of time here, but Mr. Dion, we do appreciate you coming and testifying. You have a tough job. I understand that, and I've learned a little bit about how difficult it must be. When we first started hearing about the We organization and the testimony of the different players, we heard that we heard some information, and then it was contradicted by other members of the organization. You may not want to comment in terms of who you're listening to or how you corroborate the testimony in this case, but in the cases where you get conflicting information from different sources, what process do you undertake to get to the root of it and to figure out the actual facts? Obviously, we as a committee are doing that. We are requesting additional documentation to corroborate the testimony. How would you do it?
Yeah, we do the same thing, and sometimes we end up interviewing somebody that we thought we would not have to interview when something like this arises. And at the end of the day, if there are conflicting versions, and it's my role to determine on a balance of probabilities who is saying the truth and who isn't. That's how it would happen in practice. It's not always easy. It's a difficult job. But that's essentially how we would solve it, by asking for additional documents, like you've mentioned, by interviewing additional people, and at the end of the day, making a determination as to who I believe and who I don't believe.
In terms of the testimony, obviously, one person's versions of events may impact the impact on the code and the act differently than somebody else's interpretations of the events. That were undertaken. I think specifically about the Trudeau family's testimony that they were paid for speaking events, and then when the organization says no, it wasn't in fact for speaking, but it was actually to have a relationship with corporations that in many cases the government would have some relationship with or would obviously regulate. In those cases, how would you make a determination with regards to if or not they broke the code and the act? If one was testifying that they were simply speaking to a bunch of youth, and another testimony was that, in fact, they were there to serve a corporate interest.
Is it going to take
again? I looked at the totality of the facts and basically come to a conclusion, which I share in my report, with the Speaker of the House in the case of the code, and with the Prime Minister in the case of the act. That's how it works. And the interpretation I give to the act is essentially cannot be attacked anywhere. It's final. Because there are several gray zones, like in any other field of law. It's not always black or white.
Well, you're the final arbitrator, I guess, on a lot of this, and so we understand that. Mr. Chair, were you indicating my time was up?
No, 2 minutes, less than 2 minutes now.
Okay, I do apologize. I thought maybe you were intervening there. In terms of the larger picture, in terms of the amounts of money that were committed to the WE organization, and then the decision by the WE organization to not only discontinue its relationship when scrutiny started to be leveled against them, but obviously, even going so far as to shut down their organizations in Canada. Is there any risk that their ceasing operations in Canada will have an impact on the continuation of your review of those events?
You see, there is a risk. Come across the real situation yet, so
there is a risk that if they completely curtail operations,
it would be it's sheer speculation because we haven't come across that situation and we have not anyway. It's not relevant at this moment. So.
Okay, I appreciate that. I just got a sense that when members resigned, that your investigations were impacted, and so I worried that if they continued to curtail their operations here in Canada, that may render an impact on your study as well. But I guess we'll cross that bridge when we get there. Thank you so much.
Thank you very much, colleagues. Commissioner, thank you very much for taking the time to testify before our committee. We greatly appreciate it. We need a little bit of time to transition now to our next meeting because, of course, it's hybrid like this one. So it'll take a couple minutes. But colleagues, unless you need a break, while we transition, I just wanted to read you something because of a question that was asked by. Yeah, we can suspend and then. Sorry, colleagues, I'm just doing something with IT here. So, yeah, we can officially suspend and then. But I'm as long as they're online, I just want to clarify something with them. So we'll start with your remarks and go into questions and answers. I think you know the drill, so please go
Yes.
ahead with the 7 minutes for your opening remarks.
Good afternoon, Mr. Chair. This is the first time we have an opportunity to meet. Committee members, bonjour.
Hello.
Appear before you today to discuss the administration and enforcement of the Lobbying Act over the past several months. As the Commissioner of Lobbying, I'm accountable to Parliament. My mandate includes the following 3 areas of activities. Premièrement, je dois
First of all, I must establish and maintain a registry of lobbyists. As the main tool for enabling transparency of lobbying activities, the registry provides Canadians with information about who is communicating with public officials and about what subjects. On any given day, there are about 6,200 active lobbyists registered. Since February 2020, of the over 6,000 posted registrations, 1,757 were new. Since February, also, lobbyists have also provided details with respect to more than 21,000 arranged and oral communications. When compared to the same period in 2018 and 2019, it's clear that more communications are occurring in 2020, while health was the top subject registered and communicated in February, March, and April 2020. Economic development became the top subject in May and has remained so ever since. To make it easier for Canadians to identify and track lobbying activities directly related to the pandemic, the office created an easy-to-access search feature of registrations on that topic. There are currently 640 such registrations. Second, my mandate includes raising awareness of the Act and Code with lobbyists, public office holders, and other stakeholders. Since the beginning of the pandemic, to assist those who were new to the registration process, our client services team provided assistance. As the government announced funding programs related to COVID-19, we published guidelines to ensure continued compliance from lobbyists. We also gave presentations to lobbyists and public office holders on the lobbying regime. This means that more than 300 individuals now know more about the requirements of the Lobbying Act and Lobbyist Code of Conduct. The office's website remains the main tool to reach lobbyists and the public. A new website was launched in April 2020.
Enforce the Act and Code. Allegations of non-compliance with the Act and the Code are dealt with in 2 steps. First, a preliminary assessment is undertaken to evaluate the nature of the alleged contravention, obtain initial information, and determine whether the subject matter falls within my jurisdiction. Following this assessment, and when necessary to ensure compliance with the Act or the Code, an investigation is commenced. When I complete an investigation under the Code of Conduct, I table a report to Parliament. When I have reasonable grounds to believe an offence under the Act has been committed, I must refer the matter to a peace officer, most often the RCMP. Offences under the Lobbying Act include failing to register, failing to file a monthly communication report, providing inaccurate information, and lobbying while subject to the 5-year prohibition. Since April 2020, I have opened 16 preliminary assessments and currently have 5 ongoing investigations. Also since April, I have referred 3 investigation files to the RCMP. As of today, there are 11 files with the RCMP. When such a referral is made, I must suspend my investigation until the matters have been dealt with. Only once this has occurred can I complete my investigation and report to Parliament. The Act is clear that I must conduct my investigations in private. That means that I cannot comment. These matters may become criminal investigations, and I cannot jeopardize them. Although I am unable to comment on cases, I'd like to highlight certain aspects of the Act as it relates to some of the issues that the committee is studying. Under the Lobbying Act, communications in relation to the awarding of a contract is a registrable activity, but only for consultant lobbyists, not for in-house lobbyists. As well for in-house lobbyists, the Act requires that the most senior paid officer of the organization or corporation file a registration when the collective lobbying activities of the organization or corporation represent a significant part of the duties of one employee. The significant part of duties threshold has been established at 20% of more of overall duties. When this threshold is met, the senior officer has 2 months to register these activities. When it comes to the 5-year ban on lobbying for former designated public office holders, the Act prohibits these former officials from lobbying as a consultant or as an in-house lobbyist for an organization. However, if a former designated public office holder is employed by a corporation, this individual is entitled to lobby as long as the communications do not amount to a significant part of his or her work. Like any other allegations of non-compliance, these elements are all assessed when conducting a preliminary assessment or an investigation. Comme je l'ai déjà mentionné au comité.
As I have stated to the committee in the past, the significant part of duties threshold should be removed from the Lobbying Act, and this will be one of my recommendations should the Lobbying Act be reviewed. I would also recommend the elimination of discrepancies related to in-house lobbyists regardless of whether they are employed by a corporation or organization. I believe that this would increase fairness and clarity in ensuring that both corporations and organizations are subject to the same requirements. Finally, with respect to the impact of the pandemic on the results achieved by my office, I have been impressed by the team's ability to work together and continue to deliver excellence during a time of heightened stress and insecurity. Not only did the employees of my office adjust quickly to a new way of working and find ways to support each other virtually, they continued to ensure the delivery of all aspects of the mandate. For this, I am very grateful to each and every member of my staff. Mr. Chair and committee members, thank you, and I welcome your questions.
Madame Bélanger, now on to Mr. Barrett.
Thank you, Ms. Bélanger.
Minutes.
Well, Commissioner, thank you very much for joining us today. It's a pleasure to see you again, even though it's only in virtual format. Can you tell the committee how long it usually takes your office to compile and release a report on alleged illegal lobbying once you've started it?
Well, that is it's a good question. To issue a report to Parliament or to issue a report to the RCMP?
To issue a report to Parliament.
Well, to issue I haven't done one yet. Okay. My reports to Parliament have been on the Code of Conduct. On breaches of offences of the Act, I have sent 10 reports to the RCMP, and therefore I can't report to Parliament until those either are individuals are charged with or they come back to me because they don't plan on charging them.
Right, and so there'd be it'd vary each time once you detect or suspect criminality and you make that referral to the RCMP. That could happen really at any juncture during your investigation.
Well, if we consider that I've been in office for a little less than 3 years and I have sent 10 investigations to the RCMP, I would say that on average some may have taken 3 months to send there, and some may have taken less than a year, obviously.
Okay. In your view, should post-employment restrictions for designated public office holders in the Lobbying Act be extended to apply to former public office holders, such as members of Parliament who are not currently covered?
I'm not sure I fully understand the question. I mean, every former designated public officer is subject to the 5-year prohibition. unless, of course, they work for a corporation and the activities of lobbying would be less than 20%. So there is a small exemption there. And I do believe that I find that there's no explanation for that exemption, and it should be the same for whether or not you work for an organization or corporations. But currently, everyone that's a former designated public office holder is subject to the 5-year prohibition.
Do you believe that all members of the House should be included?
Members of the House are currently included.
Okay. So in the Lobbying Act, with respect to an organization with in-house lobbyists, to register within 2 months of the time when the combined lobbying activities of all employees over a period of 30 days amounts to at least 20% of the work of a single full-time employee. Could you clarify for us what that usually looks like? And I appreciate that you did touch on this during your opening remarks.
So what this means really is if you look at the total of the communications of all employees, if you added this all up, it would amount to approximately 1 day of an employee's work per week, which is about 30 hours, 32 hours a month, if you look at it in a month's time. When we calculate it, it's not an easy task. It is a bit of a burden because it's to look at how many communications occurred, how much time was spent on these communications. It is also about the preparation time. It's the presentations that are being done, the length of the communications, and then the meetings. We add all this up to determine whether or not 30 hours was met within a month.
Okay. There, as you know and have stated, there was a review of the Act set to take place in 2017, and 3 years later, that has yet to take place. We have just about 2 minutes left in my questions to you. Could you share with us what your recommendations you have for the Act? Because in a minority context, we don't know when the next election might be, and we might have another election before that review from 3 years ago, due 3 years ago, actually takes place.
If you've ever taken the time to read the Lobbying Act, it's extremely complicated and has a lot of little issues that should be fixed. I can't fix it all in the context of a review. So the approach I have taken is values-based. So unless the recommendation enhances transparency, efficiency, fairness, and clarity, I'm not going to bother. So I've come down with approximately 13 recommendations. I'm consistently looking at them again and adapting as my experience grows and as time goes by. Clearly, the eliminating significant part of duties, hopefully enhancing a spectrum of sanctions, because right now it's either a report to Parliament or the RCMP. Certainly harmonizing the time limits between 10 days for a consultant to register versus 60 days for an in-house lobbyist. Eliminating the inconsistencies between what in-house corporations and organizations have to disclose on the website. What other ones do I have? I have, that's about, oh, sorry, I can't hear you.
Sorry, if I can just interrupt, I think I have about 30 seconds left.
Sure.
So I do appreciate your responses, and I have looked at your recommendations, and thank you for sharing some of them with us today. My last question is, and while I know the answer, I'd just like you to share for folks who are listening that you cannot, in fact, confirm what investigations are ongoing in your office.
I can't. I can't confirm. I'm doing the best to be as transparent as I can by giving you numbers, which I hope gives some comfort to the committee that we are really on top of the files. But no, I can't confirm which investigations I'm looking at.
I appreciate that very much, ma'am. Thank you.
Thank you, Mr. Barrett. Thank you, Madame Belanger. And even though it's public knowledge, maybe if you do table those recommendations with the clerk, then we could very well incorporate them into whatever report we do after this study. Now we'll move on to Madame Shanahan for 6 minutes.
Thank you, Chair, and thank you, Madame Belanger, to appearing before us today. I just want to clarify for the committee and those listening to us, what is the difference between a designated public office holder and a member of the House? I'm not sure that I caught that in the last change.
The Lobbying Act identifies two groups of people: public office holders and then designated public office holders. Public office holders are practically all public servants, members of parliament, senators, and their respective staff and GIC appointments. So if somebody communicates with any of them, they must register as a lobbyist. Designated public office holders are ministers and their staffs, senators, members of parliament. When a lobbyist communicates with them, they have an additional burden to do a monthly communication report. They actually have to go in the system to add that they've had a discussion with these people. But the designated public office holders are also individuals that when they leave office, they are prohibited from lobbying.
And if I understand correctly, it is the responsibility of the lobbyists to make sure that they have complied with those rules?
The lobbyist who, yes, absolutely. When they communicate with you, it's on their shoulders to make sure that they register those communications, yes. However, I would add that we do have a system imposed by the Act where we need to verify the content of these monthly communication reports. So you may receive sometimes an email from me that says, can you check this verification? And you have the obligation to answer me to confirm whether or not the information that has been put in the registry is accurate. And we do a 5% sample every month. So you may have been contacted before or not, I don't know, but that is a heads up that you may get that once in a while, not to be thrown into your junk box. Please
I hope it isn't thrown into the junk box. Thank you. Thank you for that. So just to, again, for the purpose of clarity, in your mandate, and you did mention sort of the three major tasks that you have, does this include overseeing all buying and selling transactions with the Government of Canada?
No, procurement is not part of my mandate. However, lobbying is a registrable. Awarding a contract, communications about awarding a contract is a registrable activity if you're a consultant lobbyist. It's not if you're an in-house lobbyist. But I do not regulate procurement in government, no.
So the buy-sell website, for example,
no.
Those businesses that register there,
no.
You do not oversee that?
No.
All right, thank you. How would you rate the lobbying disclosure regime in Canada, Mrs. Belanger? Are we on par with other countries, or are we ahead of the curve?
I think we're ahead of the curve in the sense that we are internationally a model, so people look up to us quite a bit. And we have fantastic people who have been working on this registry, and people only have good things to say about the registry. It works well. Having said that, there needs to be improvement, and I would highly recommend the committee look at the new BC legislation that was adopted in May. They have their law has changed and has fixed some of the issues that I have with our rules. So the registry works well, but what needs to be on that registry, some of it needs to be fixed up.
Thank you. Mrs. Belanger, you did give us some figures about the type of the number of activities that you have had to deal with in an average year prior to the pandemic. Could you just compare that quantity and maybe talk a little bit about the quality to what you're experiencing now, what your office is experiencing now during the pandemic? Because you clearly indicate that it has increased dramatically.
Yes, if we compare, comparing to 2019 is not really fair because it was an election year, so the numbers always go down in any event. But if I compare the numbers to 2018, the full year of 2018 was 27,000 communications, monthly communications. We're already at 21,000, and there's still 4 months left in the year. Summer months usually are in the 1,500s. This past summer, the numbers per month were closer to 2,000 communications. So I could share stats per month if you want, but for sure, if you compare summers and if you compare total, the last few months have been extremely busy.
Well, and do tell us about that, because obviously we were in an extraordinary period. I remember when the COVID-19 mobilization call for action went out. Can you talk to us about, with all of the emergency programs and the extraordinary response of industry and commerce to that call by the government? Can you talk about what that meant for your office?
Yes, of course. I have a team of only 3 individuals in the client services. In fact, I have a team of 28 employees, so we're very, very small. And these 3 employees were extremely busy helping out the new 1,700 registrants who had really no idea how to do this. So we were front and center in helping them to register. We also very quickly develop guidance for individuals to know whether or not they should register, because sometimes all that people do is apply to get a grant, and then just applying is not lobbying. And so we had to clarify that. Sorry
to cut you off there, Commissioner.
Okay.
I gave you some extra time to finish it. It was an important answer, but we're kind of way over in that segment. Now on to Madame Goudreau.
Merci.
Thank you, Mr. Chair. Hello, Ms. Bélanger. It's a pleasure to see you again. You came to see us at the first session, and now it's always easier when it's in person and then afterwards virtually. So as I don't have 2.5 minutes, I have 6 minutes. I have a few questions for you. The first being, first off, what is your, collaboration? What collaboration do you have with other commissioners in the course of your work? And my question focuses on, for example, when we talk about a watchdog effect to help each other if there are possible alerts of what's going on. So how is that handled? Well, actually, we each have our separate mandates, and we also have our own specific obligations to keep information confidential. However, what I can say is that parliamentary officers, since the pandemic, I believe we met twice, in the course of which we get a feeling for how things are going and how the employees are doing, and if there are things that we can do to assist each other, if we can share ideas. For example, at one point, I provided a guide for the return to work, which we share among us. And if there's any training and if there's a shortage of employees, we have such a small group that if I need to do a French language training, then I don't have enough people to do it, and I have to communicate with them. So we help each other out. There's no watchdog function, though, is there? As Mr. Dion, the commissioner, said earlier, he keeps track systematically of what's going on in the committees, and what we experienced this summer when we learned that Ms. Marquez was not registered in the registry of businesses. Is that information that you have systematically and that you can intervene? Yes, absolutely. I'm not sure if I understood the question. I thought you wanted to know what discussion we had between the... Well, I'm talking about a whistleblowing function. Well, you've seen my statistics. I started 16 preliminary evaluations this summer. I am very, very keeping track of what goes on in parliamentary committees. I listen to them myself. I find it very interesting, and I keep track of what's going on in the media, and that's it. So yes, I'm very much keeping track of what goes on in Parliament, and often this is what encourages me to go and take a closer look at what's happening elsewhere. One more specific question regarding Palantir Technologies. As we know, the former ambassador, candidate to the U.S., Mr. McNaughton, also was involved in the negotiations of the CETA and was also reprimanded for inappropriate lobbying actions. So what I want to get at is that the fact that he easily got access to the Deputy Prime Minister and also Minister Baines, are you surprised? And I'm asking for your interpretation. Are you surprised about how easy it was for Mr. McNaughton to have meetings like that?
I don't think I'm the person you should be asking this question to. I'm responsible to see if a designated public officer who was not allowed to lobby did lobby. I cannot talk about this issue I don't think I'm the right person to give you my personal opinion about this. Sorry. Okay, very well. Then I'll just ask another question. Let's talk about We Charity. We Charity communicated with 19 federal entities over the span of 18 months. We all know this. And in August, 3 representatives were witnesses before our committee, and they then registered as lobbyists. And how can you explain this, since, as we know, that We Charity did receive millions of dollars? Answer: I would not like to talk about this file because I can't speak about it specifically, but what I can tell you is that there seems to have been a wrong interpretation of certain sections of the law. Some people said the government communicated with us and it wasn't the contrary. So who communicates with whom? That's not necessarily pertinent in this case in order to determine if there was lobbying or not. I think there was a lack of understanding of the law. And what I'd like to say as well is that the media mentioned that there had been a registration in the registry and this would pardon everything. When you decide to register in the registry, I do want to say that I want to encourage transparency. You were able to see what types of communications occurred, but that does not mean that this will stop my investigation just because they registered. Thank you very much, says Madame Gaudreau. I would like to thank you, and I would like to thank you for the work that you're accomplishing. There are a lot of gray zones, gray areas, and there is a lot of important information that must be given to people because the consequences are very heavy consequences. And I think that your 13 recommendations should become a priority because we often lose a lot of time in committees. I see that you've been following our committee, so you see what I mean. And I think that this should be a priority. We should focus on prevention, and this is what we're doing today. I don't think I have any time left, do I?
Much done, Madame Gaudreau. Merci beaucoup.
Thank you very much.
Alors, merci beaucoup, Madame Bélanger.
Bienvenue, merci.
Thank you, Madame Bélanger.
For 6 minutes, Mr. Angus.
Can't hear you. I can't hear Mr. Angus. Oh.
Mr. Angus, you're muted. You need to unmute yourself.
Yay. Some professional me, eh? Madame Bélanger, thank you so much for coming. In September, you stated that you had begun a preliminary investigation into the WE issue. Is that investigation complete? Is it ongoing?
I cannot answer that question, unfortunately.
Okay. Well, I understand. It's just I'm just wondering if it was set aside and there was no problem.
If I can clarify on that point, it would never be set aside without me reporting to Parliament at some point. I want the committee to know that I am very much aware of what's of interest to you. And when I'm able to report to Parliament on these matters, I will.
Okay, thank you for that clarification. For many of us who got involved in the investigation, it was quite the surprise because the extent of the WE group, the multiple corporate entities, and the complexity of their organization certainly took me aback. I thought they just did stuff with kids, but it's very organized. But the Kielburger brothers have really specific interpretations of the Lobbying Act. They said that because a good percentage of their income didn't come from government contracts, they didn't need to register. So is there a threshold, a financial threshold in the Lobbying Act that they could have avoided registering?
No, there is no registration threshold. What happens is that the act is written in such a way is if you have to be a paid employee or a paid consultant, and you have to be communicating on behalf of your employer.
Right.
And therefore, there is no threshold with respect to salary. If someone is a volunteer for an organization, clearly a volunteer, then they don't need to register.
Well, that was the second reason. Craig Kielberger contacts Bill Morneau on April 10th, says, hey, Bill, hope you, Nancy, Henry, Claire, Edward, and Grace are enjoying some well-deserved downtime, and then begins to negotiate a $12 million deal. There's multiple meetings, and Craig Kielberger is the key person, and he says that he doesn't need to register because he's just a volunteer. He's the founder. They can fire their board of directors. We, as a very complex corporate structure, we don't know how they get paid. Would it be reasonable to assume that he was just volunteering, therefore, like any volunteer, just helping out, as opposed to someone who's actually playing a key role in getting these contracts? Would that be considered lobbying?
If someone is being paid by somebody, and this the organization that's paying them may benefit from the lobbying, I would consider that to be someone who needs to register.
Right.
And I'm very much aware of the facts that you're raising, and I would prefer leaving it at that for now.
I totally understand, because again, we're trying to find through all these corporate structures who actually pays the Kielbergers, but there's a lot of money going through.
Mm-hmm.
Now, Sofia Marquez is listed as their Director of Government Relations. That seemed to me to be something that would be considered a standard lobbyist. They said she didn't do enough work to cover that, but in January of 2020, they were hiring a manager of government relations. Would you consider an organization that has two people dedicated to government relations to be involved in lobbying? Hypothetically.
With respect to any organization that has anyone doing government relations, we would have to look at the number of communications that they have done, and the number of meetings, oral and arranged meetings that they would have occurred, how many presentations they have done, to calculate whether or not they meet the threshold. Someone who's full-time and communicating every day, possibly likely they meet the threshold, but it's a case-by-case basis, really.
Right. Well, I'm glad you asked that, because after we asked these questions in committee, they did register, and I count 44 meetings. I mean, they met with everybody, Assistant Deputy Minister, Senior ADMs, Madame Chagger, Madame Ning, the PCO, right into the Prime Minister's office. This was pretty extensive, and what was being negotiated was a $912 million contract. Now, they said that they registered after the fact because they were being, good charity, a good charity. Because they register after the fact, and because after Parliament shines the spotlight and says, how come you had all these meetings and you didn't register? Are they absolved? Like, hypothetically, an organization that gets found out and then registers, would that be okay?
They're not absolved.
Okay. I'm running out of time here, and I know you probably can't answer, but I noticed that Democracy Watch asked that the questions of illegal lobbying by we be referred to the RCMP. Would you feel that if you had enough evidence that this would be a case that could be referred to the RCMP? Because you said you referred a number of cases to them.
I've referred 3 matters so far this year. Absolutely. If the evidence is there that there's reason for me to believe that an offense has occurred, I will refer the matter. I've referred 10 since I've joined this office, so that the threshold is not that very high. So when I do have reason to believe that an offense has occurred, once I've started looking into it, I will refer the matter.
Well, we thank you for your dedication.
Thank you.
Thank you very much, Mr. Angus, Madame Belanger. Now we're going to move to the second round, which is a 5-minute round. Prochain député, Monsieur Gourde.
Mr. Gould, you have 5 minutes. Thank you very much. Thank you, Madame Bélanger. I'm very pleased to hear you, and I'm very pleased to see you today. I must tell you that I'm very pleased to see that the work that we're being done is being followed closely. I'm very pleased about that, because some people did doubt the pertinence and the relevance of what we were doing, and I'm very happy to see that you are following us and that this is something that is dear to your heart. You stated something that I found a bit strange. I know that you can't divulge everything, but it was something you said about people that contacted federal organization and people that didn't need to register to the registry of lobbyists if they wanted to promote certain products or services, or if they wanted to get information from the government. But if we see that an organization doesn't think they have to register just because they didn't communicate with the government and they say the government communicated with them, this shows how closely tied they are to the government. I found that very surprising. It's the very first time I hear this, that an organization did not want to register because they didn't have to solicitate the government. The government was communicating with them, and they didn't even need to communicate with the government. Does this proximity worry you? Answer. Of course, if there is a wrongful understanding of obligations, this does worry me. But I've seen that a lot of people are registered, so most organizations and corporations understand the law. I see organizations, and they often say that they don't think that they meet the threshold. They don't think that they meet the threshold, but they still do register for transparency reasons. So, of course, I am worried when people do not understand the law properly, and I do work with my team on education and outreach. We're sometimes talking about contracts of under $25,000 for direct contracts, and there is no submission because it's not a very large amount, and sometimes things go quicker that way. But when you go over a certain threshold, you can't just award a contract directly. And is this $25,000 still the threshold or not? Answer. Awarding contracts is not what does not come under my mandate. You have to register to the lobbying registry when there are contracts. If there are communications about the awarding of contracts, this is not lobbying per se, because there are rules about awarding contracts, and there is a certain fairness in this, and there is also a transparency that is expected. But communicating about the awarding of contracts is not lobbying per se. Question. When the government establishes a program or awards a contract of hundreds of millions of dollars, automatically certain mechanisms have to be put in place, and it is important that the organizer or the company will be able to fulfill its obligations under the contract. And it's just interesting to see what happened when a contractor is speaking about his strengths and we just don't have the name of the contractor. Don't you find that this was strange how it all came about? Answer. There is the awarding of contracts, but there are also contribution agreements. Contribution agreements are lobbying. So I don't know if we're talking about the same thing here. If you're speaking about awarding contracts, I think that you should probably talk about this with the ombudsman who is responsible for this file and responsible for the respect of rules in the awarding of contracts. Question. During your presentation, you talked about certain departments. Which are the most popular departments who ask you questions? So there's the House of Commons. This is not a ministry or department per se, but the House of Commons is asking us a lot of questions. There's also the Department of Innovation, the Ministry of Finance, Department of Finance, and Health Canada. Thank you very much. Mr. Gould.
5 minutes.
Thank you, Mr. Chairman. Thank you, Ms. Bélanger, Commissioner Bélanger, for being present amongst us today. I'm new on this committee, and I must admit this is quite the meeting and very informative, to say the least. So Commissioner Belanger, would you say that there is a pervasive problem in Canada with regards to a lobbyist trying to circumvent registration and reporting requirements?
A pervasive, no.
No.
No, no. You know, I meet lobbyists a lot, and they are they're government relations expert. They work on their reputation, and nobody wants to be on the front page news and possibly have committed a criminal offense. So, no, I don't believe that.
Okay. Since the lobbyists, I've listened to the questions posed by my colleagues and your answers. So, since it is the lobbyist that has the obligation to register, how about the reporting of interactions with someone such as myself, since I am a designated public office holder? Where does the onus lie in regards to the tracking and the reporting of the interactions that we've had?
So I think, I mean, obviously the lobbyist has the obligation to go in the registry and put in that they've met with you and about what topic. They'll put in the date and they'll put your name and the topic of conversation. I do a sample check. So you may get an email from me saying, can you please verify this information? And so my recommendation every time I meet any designated public office holder is please, please, please keep your calendar, your agenda very clear about who you met and about what, so that when we do reach out to you, you're able to confirm the information. So it's really to ensure that you keep your information live about who you met and about what topic.
But obviously the registration, that the onus of the registration and the tracking of it is on the lobbyist.
It is, although in the Act, you have an obligation to reply to me when I ask you to verify.
Okay, so just to make sure I understand this. So, and running a quick check of the following scenario based on, you know, my understanding of the answers. So clearly I'm a designated public office holder, and I do from time to time meet with people and certainly with, you know, different associations and people and parties that are interested and classify themselves as lobbyists. So when I do meet with them, I typically take their meeting with me at face value. So mainly they have registered, you know, as required, as you just said a few minutes ago, and I have to log in the intervention had with them. So if in fact they were not registered and had not logged the interaction, that error or omission is on them. Am I correct to assume that?
Yes, absolutely.
Okay. And do I have any requirements to look into their registration status myself?
You do not have that obligation under the law currently, although I encourage you to do so. Only because it has happened very often where I have allegations, and I will reach out to every one of you because you become witnesses in my preliminary assessments and in my investigations. And if I say, you know, how was this meeting? It's not up to you to check that they're registered lobbyists, but I highly recommend that you do. I actually tell your staffers whenever I meet with them, and I met a number of them yesterday, and say, you know, go check the registry before you meet with somebody. You'll see who they've met with before and about what topic.
Okay.
It's an interest.
Sorry, I didn't mean to cut you off. Speaking of staff, so I'm going to take it further and basically ask you the same question. Of course, my staff will not have that obligation either, correct?
Correct.
Okay. Just wanted to, again, for sake of clarification, give you another example. So if companies and individuals who are selling products to the government have to register as, do they have to register as lobbyists? So for example, if Microsoft salespeople need to register the meetings had with government officials, do they have that obligation?
If all they're doing is selling a product, because it's a contract issue, no. If they're meeting with you to try and get you to develop a program or to develop a policy or to develop or want to talk to you about a regulation that you're working on or a legislation you're working on, then yes. But if they're selling products, no.
Thank
How
you
about
very
if they're
much,
selling?
Madam Latanzio and
Sorry.
Thank you.
Madam
No, it's
Belanger.
okay. That's fine. Thank you.
We're going to move on to this this rapid fire round now. Madame Goudreau, 2 minutes et demi.
Ms. Goudreau, you have 2.5 minutes. Thank you. You said it very well, Mr. Chair. I'll be quick. I echo what was just said. Earlier, you talked about recommendations. So I was thinking, if someone recommends me something, and say, I represent the government, I am a public office holder, it means that your recommendation will be valid to show how responsible we are as leaders.
Perhaps didn't turn off or switch her channel to French, because her voice is much louder on my microphone than the interpreters. I can't hear what the interpreter is saying.
Okay.
Sorry
I'll
about
just,
that, Madame
I'll just
Goudreau.
check with Madame Goudreau, and I'll add some time to your speaking there, Madame Goudreau. Commence.
Yes, maybe I speak loudly. And then earlier, the interpretation was also loud, but I speak less loud. Okay, so the recommendation you gave could become the law if we want to show that we are responsible and lead by example. Then we should follow your recommendation. Right now, your responsibility is to answer to my questions and confirm the information that are in the registry. So this is why you have to track who you are meeting with, because it would be, it's a little bit, it's not great when if I ask you if you know this or that lobbyist, you tell me that you don't know that person. Lobbyists have to register information related to meetings they might have had with government representatives. And when I contact you, you have to tell me whether that meeting has happened or not. What can you show? What can you do to show that you're neutral? Because there are many gray zones. So what are the existing mechanisms to show that you are not neutral? Well, I have always been a public servant. I am a neutral person. I am nonpartisan. I've never had any political affiliation. I show a lot of integrity, and I want everybody and myself to comply with the law. I have a team of 28 members, and all members of my team are neutral. I also have a background as a lawyer. I have a last question, Mr. Chair. I wasted some time with the interruption earlier. Can I ask my question? It will only take 20 seconds.
And gave you extra time.
Il n'y a pas de problème. C'est quoi les sanctions?
All right, no worries. So what are the possible sanctions if we forget to register ourselves or to send a report?
Right now, it's our CMP, and there is really nothing else. Or if it's a breach of the code, it's a report to Parliament. I have no spectrum of sanctions, which is why it will be one of my recommendations. Je m'excuse, j'ai répondu en...
Sorry, I replied in English. I'm so sorry.
Mr. Angus, for 2.5 minutes, please.
Désolé.
Thank you, Mr. Chair. I'm very interested, Madame Belanger, you were saying about obligations, about when you need to register and when you don't, because I meet with all kinds of charities and local charities and national charities. But you said that if a group is trying to develop a program, meeting with ministers or meeting with minister staff about developing a program, they have to register. Is that correct?
They have to register if they meet the 20% threshold. Yes.
Right. So in the case of the Kielburger group, they were trying to promote developed two programs. One was the entrepreneurship program with Minister Bill Morneau, which was $12 million, and the Canada Summer Service Grant for $900 million eventually. That's a lot of money. Now, we talked about this issue of them classifying themselves as volunteers, which I think is kind of difficult to figure out given their structure. But you said, I found really interesting, if someone's getting paid by somebody, it may meet the threshold, and that's interesting. I would ask you if you've looked at the contracts that were signed with the between the government of Canada and what was the holding company that was set up, because the Kielburgers in testimony said again and again that 100% of the money was going for young people. They were not taking a dime. They made that very clear. But the contract showed easily a 15% administration fee for their organization, and they have many staff, and all their organizations are intertwined. But also, the government of Canada was going to pay $560,000 in rent. That's $500,000. And we know that the Kielburgers had multiple real estate holdings in the city of Toronto that they were trying to hold on to. So hypothetically, if people are getting paid for their real estate, if they're getting paid for their staff in one of their organizations, if $50+ million is being funneled through an organization, somebody's getting paid. Is it possible that could meet the threshold for someone getting paid and needing to register?
Well, the requirement to register is that you're paid by somebody to lobby about something that your company will benefit.
Yes.
And
I'm just wondering about the Kielburgers specifically.
So I do not want to talk about specific cases. I can't. I really can't. But what I will tell you, that our investigations, our preliminary assessments, everything that I do, we do it extremely thoroughly.
I bet you do. Thank you so much.
Very much. Thank you very much, Madame Belanger and Mr. Angus. Mr. Workington, we only have 3 minutes left in our meeting, so you have 3 minutes.
Thank you, Mr. Chair. Thank you, Commissioner. I'll keep this tight. I do have a question, and it is this. What conditions could lead you to abandon an investigation midway? Is there anything that could happen outside of your control that would lead you to discontinuing an investigation?
I can tell you the only time, and it has happened, where I've ceased an investigation because the law permits me to do so, is that it becomes extremely clear that we began it possibly under false assumptions. So it becomes very clear, like, for example, we'll start investigations because we believe someone arranged a meeting. We started and clearly there was no arranging of a meeting that occurred. I will cease it. There is no point in pursuing something and possibly reporting to Parliament on something that really wasn't. It doesn't happen very often, but it does happen. And I have to, with the amount of staff and resources that I have, when it's not worth it, because clearly there is nothing there, the foundation for which we started is no longer there, I will cease it.
If a company ceased to exist who had been paying a lobbyist that you were investigating, would you cease it then?
No.
That's very helpful. In terms of trying to weed through, if a company is being paid by one organization to benefit an affiliate,
Rappel au règlement, Monsieur le Président.
Pardon me, I think something's wrong with my...
Monsieur le Président, si le micro n'est vraiment pas bien...
Mr. Chair, the mic is not positioned properly. It's very hard because the sound of interpretation is already low.
Yeah,
Merci.
Thank you.
Are you able to, let's test that? No, it's still doing it, Mr. Chair. I probably is best that I discontinue then.
Okay, thank you very much, Madame Belanger. I appreciate you taking the time to testify before the committee. I had just briefly now, since I have a minute, I was thinking in regards to your training staff, etc. Would it be advisable? Maybe you haven't thought of it, but as you were talking to my colleagues, I thought maybe when I confirm appointments, I will put at the bottom of the confirmation email that if you're a lobbyist and you haven't registered with the Commissioner of Lobbying of the Parliament of Canada, you could be committing an offence. Would you welcome something like that on a confirmation email to a meeting?
That will certainly scare people. Absolutely. Absolutely.
Well, no, it's serving them due notice.
Absolutely.
So thank you very much again, Madame Belanger. Colleagues, we're going to adjourn, but I want you to know that we will begin our meeting at noon on Monday, not at 11. We only have one witness, so I figured that rather than start at 11 and go till noon, we'll start at noon and go till 1, and that way, for those of you who do travel to Ottawa, that'll give you an extra hour in your traveling, and we'll begin then with the singular witness that we're able to. And again, we've done everything we could. Kudos to the clerk of trying to cajole, encourage, phone back, email, and that's all we were able to do for Monday. But we do have our meeting starting at noon on Monday. So have a great weekend. Please be safe. Bonne journée. We're adjourned.
Have a great day.